Hi, my name is William Campbell with Fitzgerald Campbell, a professional law corporation, and I wanted to talk to you a little bit about what kind of debts fall under state and federal FDCPA here in California. Now, there's really two requirements for the debt in order for it to apply, and that is one, it must be a consumer debt, and two, the debt must be in default. Let's talk a little bit about what a consumer debt is. Now, the law defines a consumer debt as a debt incurred primarily for personal, family, or household purposes. Well, what kind of debts are those? Those are things like student loans, personal credit cards, medical bills, things along those lines. What that does not include is a debt that you incurred through your business by buying barrels of coal for your business. So if it's a business debt, it doesn't apply. It's got to be a consumer debt. Now, that doesn't mean that those who have business debts can't be helped. It's just a little bit more difficult regarding the FDCPA and the California Rosenthal Act. So, now, what is a default? The FDCPA does not define a default. Now, that creates a big problem because there's mixes all over the United States. Courts have adopted different rules about what a default is. But in general, they have said that a default is determined by either state or federal law or by the terms of the contract which created the debt. So when you signed up for your credit card, in that particular document, it might say what a default is, in which case that would be adopted as determining whether the debt is in fact a default or not in default. In some of the cases, the dictionary definition of default has been used, where the contract left the determination of default to the discretion of the creditor. Now, the FTC has weighed in on this and said that in the absence of a contractual definition or conclusive state or federal law, a creditor's reasonable written guidelines may be used to determine when an account is in default. Now, some of the courts did not like that definition, and some of the courts have said, look, we're not going to leave it up to the creditor to determine whether or not the account is in default. Now, usually in cases regarding FDCPA, federal and state, the account being in default usually is not an issue. It's usually in default, and it's obvious it's in default because the collection letters will say it and so forth. So usually this isn't an issue, but when you're talking about state and federal FDCPA, you want to make sure that your debt is a consumer debt, and you want to make sure that it's in default before you can bring these kinds of cases forward. Now, if you are being harassed, there's a couple things you need to do. Sure, first, make sure your debt is a consumer debt. Like I said before, look at your contract. See if it contains a definition of default. And if you find that your debt is a consumer debt and that the debt is in default, you may have a federal or California FDCPA claim, in which case you probably want to talk to a lawyer. My name is William Campbell from Fitzgerald Campbell, a professional law corporation. Come give us a call, look at our website. We'd sure like to help you out if you have any problems, and have yourself a good day.